Moore et al.
Okay, I have a copy of an order here that says each side gets 25 minutes for oral argument. I assume Judge Clement issued that order since he's not sitting today. That's how we'll proceed. Are you going to divide your time?
We are, Your Honor. If it please the court, the plan is for, the first thing I think we need to address is, in this instance, how much rebuttal time do we get? Because normally we would get 5 minutes, but now we've got 25 to start with, so.
We don't have a rule that's hard and fast on when we have extra time given. So I'll let you have a maximum of 7 minutes.
All right, very good. In that case, may it please the court, I would like to present the primary argument for the appellant in this matter, and my colleague and co-counsel, Mr. Rassus, would present the, if it please the court, the rebuttal.
Okay, you want 7 minutes for rebuttal?
Yes, the full amount of that, please. We had intended to ask for 10, but
Well, you know.
we'll take what we get, so.
Okay, so you're going to have 18 minutes here. Is that right?
Correct, yeah.
Okay.
Yes. And may it please the court, am I ready to proceed, Your Honor?
Oh, if you are, I suppose we all are.
All right, perfect, very good. May it please the court, I'm Roger Manus. I, along with my colleague and longtime friend and co-counsel in this matter, Mark Rassus, we represent Mr. Charles Moore in this matter, who is the appellant. Mr. Rassus and I, when we got involved in this case, along about 2020, I think, took a hard look at this file, which now comprises 31 volumes of record, and it was really somewhat intimidating to look at, to try to sort through. And I'm sure that Your Honors have probably had something of the same feeling in this matter.
Yes, but we hope that you all will clarify it so much that we don't, we aren't intimidated when we begin diving into it.
Because this file contains a lot of paper, a lot of paper. But I believe that the issues in this case can be boiled down to really a few documents, a few significant documents, probably 10 or under on it. And I'm going to try to discuss those with you in the time that I have this morning. Briefly, in around about 2005, a gentleman named Harold Spears up in the Springfield, Ashland City area undertook to develop, if you will, a high-end subdivision out in Cheatham County, right up adjacent to the city of Ashland City. It wasn't in the city at the time, but it was butted up against the city limits. The project was going to be financed by a bank that ultimately became BancorpSouth, which is one of the parties in this case and to this appeal. Events occurred in the national economy in the 2008-2009 time frame, and this high-end subdivision failed for lack of money, for lack of additional money. So within a year or two thereafter, BancorpSouth foreclosed on the subdivision. I say the subdivision, foreclosed on the collateral that it had left in the matter, which consisted of about 600 or so acres of raw land and lots, platted lots, in 5 different sections of Hidden Lake resorts. Interestingly enough, one of the things that Mr. Spears had been able to accomplish was to obtain not only annexation of this development, but also final plat approval of 5 different sections. And in the course of fullness of time, after those plats were finally approved by the Planning Commission of Ashland City, about 50-something homes, lots were sold, and homes were actually holds the property for a period of time. Obviously, because it's a lending institution and a bank, it doesn't want to be a long-term owner of subdivided lots and raw land in Cheatham County. So it takes steps to protect its collateral, mowing and street lights and that kind of thing. Hires a realtor to market the lots and begins to look for somebody to purchase all of it, everything that's left, to the extent that they can accomplish that. Along the way, I think they actually sold about 10 platted lots to different persons directly from the bank. So in the time frame of 2014, my client, Mr. Moore, who had previously gotten involved in situations similar to this in other parts of the state, became interested in the matter and began to investigate purchasing what the bank had left, which consisted of platted lots and raw land. Mr. Moore is, it's not disputed really, he's a sophisticated businessman, having previously owned and worked in Thomas Nelson Publishing. So I'm not going to tap dance around that. He is a sophisticated businessman and has had previous experience in these matters. So what he did, he hired a very fine lawyer out of Brentwood, Mr. Bill Miller, who worked in matters like this. He's passed away now, and he also had lawyer Mark Hartzog, who's also passed away, and they engaged in a period of due diligence. Now, what could Mr. Moore do at that time in the way of due diligence? Well, the things that everybody gets to do when they're attempting to buy land is go to the Registry of Deeds office and search the title. So what Mr. Moore found, and anybody else in the world would have found, were 5 platted subdivisions, 5 platted sections of this subdivision. And each of those plats was fully approved by the Planning Commission for recording. Each of those plats had a attestation on it signed by, it turns out, Mr. Spears, the original developer, that the roads were built to Ashland City standards, or a bond had been made to secure the completion of those roads. Now, the other thing a person can do is make a visual inspection. So you go out and look and you see that there's 50 or 60 houses out there, and their utilities, electric, water, sewer, and roads. Now, a close inspection would tell you that the roads lacked a top coat. So that's really not in dispute. That's not uncommon in the development of subdivisions because of construction traffic that comes in. Usually that's reserved to close to the end of the project. So Mr. Moore, after negotiating with the bank and renegotiating with the bank, is concerned about the fact that somebody along the way may want to assert that he has the obligation to finish the roads, particularly the roads, and somewhat the sewer system in there, but mainly the roads. So he, in order to shore up things, obtains assurances from the bank that the roads are owned by the HOA. And more importantly, I think in terms of this appeal, reaches out to the HOA through its lawyer, Spencer Hamlin, a lawyer in Ashland City, Tennessee, and negotiates an agreement with the HOA to amend the declarations of conditions and so forth. And this agreement was signed off on by the HOA's president with the approval of his lawyer. Very specifically in that agreement is addressed the issue of Mr. Moore's responsibility should he buy the property. This agreement was signed on the 12th of November, 14, and he purchased the property 2 days later on the 14th. On that date, he got from the bank an assignment of any declarant rights that it had, and the assignment was signed by both parties, the bank and Mr. Moore. And so that assignment made crystal clear that there were no development obligations passing. So what we have are signed instruments by all three parties that are in this appeal, well, all except the town of Ashland City, and that's really a different, discrete issue that stands on its own. So there's three issues really that affect those parties. One is whether Mr. Moore can be pinned with the responsibility, if you will, of completing the roads in this development simply because he bought the property. A sort of an inherited responsibility. That's what I'll call it. And secondly, is Mr. Moore the declarant based on the amendment to the bylaws or not the bylaws, but the covenants in this matter? And thirdly, does the town of Ashland City, is it required to issue building permits in the matter? So, in a case that's been bandied about a lot, an opinion that's been bandied about a lot, and I think it's a tremendous value to us in this case, is the Hughes development opinion involving a development. It's a Supreme Court opinion involving development down around Mount Eagle Mountain. The facts are somewhat dissimilar, but there are some similarities. But the important thing about this is Justice Koch opinion, and like all of his opinions, it was very thorough in its analysis of the law. And the thing that really strikes me most about it is that Justice Koch held that, as always, the intent of the parties governs. And the way that we determine the intent of the parties in that situation, and I believe in this situation, is to look at all the documents that the parties were involved in. In this case, there are at least 5 documents that evidence a settled intent on the part of Mr. Moore not to be charged with the responsibility of finishing the original developer obligations in connection with this subdivision. Now, at least 2 of those documents expressly say those words. One of them is a document of an assignment that occurred on the 14th of November between the bank and Mr. Moore, which says we're going to assign all our declarant rights, but everybody agrees that there are no developer obligations passing here. But more importantly, the party that's initiated this party a long time ago, back in 2015, the HOA, signed an agreement 2 days earlier in which is precisely stated that everybody agrees that Mr. Moore's obligations in connection with this will be limited to paying half the cost of the top coating of the roads, up to a maximum of $200,000. But we get 6, 8, 10 months down the road into 2015, and the HOA, for reasons that are not entirely clear, crawfished on the deal and filed suit against Mr. Moore, wanting to pretend that this contract or this agreement did not exist, contending that it did not have the authority to execute the agreement. Now, what's not really in dispute about this case is that these parties showed up at a meeting in November of 2012 with the lawyer, Spencer Hamlin. They assert they've got authority to make the deal.
This is the president of the HOA who shows up with his lawyer, says they have authority.
Correct.
Signs the document.
Correct. And there's discussion about it the next day. Mr. Miller prepared the document, sent it to him. There's discussion about it the next day. Mr. Hamlin tells Mr. Chappelle, the president, to sign it. He signs it. My client's lawyer picks it up and gets it recorded. And then 2 days later, in complete reliance on this, having this piece of paper in hand and recorded in the Register of Deeds office, spends over $700,000 to purchase these platted lots and raw land up there. So it seems to me that in terms of that issue, in terms of whether Mr. Moore could be charged with having inherited any development obligations, then all of the documents executed by those parties surrounding this transaction indicate to the contrary. And that's what we're tasked with reviewing in it.
So the HOA, I understand, would be claiming that the document their president signed was not valid because he didn't have the authority and there was no meeting to ratify what he did.
Well,
is that correct? Is that their claim?
that is their claim.
Okay.
That is their claim. But they told us there was a meeting. They signed a document saying that there had been a meeting, and they didn't tell us that there hadn't been a meeting for months afterwards. Mr. Miller requesting on a monthly basis to obtain the minutes of that meeting. Now, Mr. Moore was not entitled to a meeting because he wasn't a member at the time. So, now, I wanted to discuss, I'm running out of time here. I knew it would happen to me. Always seems to do that. But I want to talk briefly about the town of Ashland City in this matter. This is a really peculiar situation where Mr. Chappelle, in addition to having been a party to this other agreement, goes down to City Hall and says, I don't think there's a bond to secure these roads, and you ought to stop writing building permits. This is 50 or 60 houses in, and after Mr. Moore has bought the property. I think probably after the lawsuit was filed. So the city stopped doing that on the strength of this statute that says there either has to be, the roads have to be completed to standards, or there has to be a bond. Well, they've taken the position that there's no bond. But the position that I believe is the correct position as a matter of law is that both the roads are completed and there's a bond. And the reason for that is the whole world is told by these 5 recorded plats that were approved by the city, the town of Ashland City, that the roads are either completed to standards or that there's a bond posted to secure their completion at the appropriate time. Now that's not on Mr. Moore. That all occurred years before he bought any of these properties. He was entitled to rely on those recorded plats when he bought the properties. Everybody else that goes in there is entitled to rely on those recorded plats, even today, even as we stand here today. That's the state of affairs in respect to this subdivision in Ashland City. So there's a substantial authority that we've cited to the court that corporate municipalities can be stopped from taking positions contrary to positions that they've taken, which have resulted in prejudice to other people. Mr. Moore now is in an unenviable position of owning this raw land and all of these already platted lots, and he can't get a building permit for any single one of them or sell any of them. He bought in good faith reliance on what was in the Register of Deeds office, and this town of Ashland City ought to be stopped from taking any position to the contrary. They've taken this position regarding this statute, but the truth of the matter is their own subdivision regulations at the time these plats were approved require a bond. They did at the time. That's the law. That was the law that governed the Planning Commission in the town of Ashland City when these plats were approved and then recorded. So I'm down to about a minute, and I would be happy to try to answer any questions that any members of the court have about this matter.
So your view is Ashland City is stopped. They have to issue building permits. Mr. Moore, because of the documents he signed, not only with the bank but with the HOA, is only bound in a limited fashion to help finish the roads, and whatever the roads cost to finish beyond the $200,000 is the HOA's responsibility.
Correct. That's correct, Your Honor.
Let me ask you, in regard to this bond, that the documentation indicates was filed earlier. Is there in fact a bond?
I don't believe that there is. Mr. Spears testified that he did not make a bond. The town of Ashland City took the position for at least a while that there was a bond, but I think sometime after this case was filed, they got to looking around for the bond and could not find one. Unfortunately, in 2010, an event that occurred that affected the town of Ashland City, I believe, was during the process of this thing, was we had the flood of 2010, and some of their records may have been lost or flooded in the course of that. But Mr. Spears said he did not make a bond, but he signed. He was allowed to sign, and it's our position, Judge Armstrong, that it was the responsibility of the Planning Commission or its staff to ensure that there was in fact a bond made, or that the roads were complete before they approved the Planning Commission. That's part of their responsibility. It's just a compliance issue. You say you've got a bond, where is it? They didn't do that, it's on them.
Thank you.
If I could, to just clarify, we've got 25 minutes for all three of the appellees, and I represent the town of Ashland City, and I'm going to take up no more than 6, and what's left I will defer to the other two appellees.
Okay. Who else do we have? Wayne? Okay. Are both of you going to argue?
Yes, Your Honor. This gentleman represents the bank, BancorpSouth Bank, and I represent the Appellant. So we've agreed among ourselves that the bank and the town of Ashland City will go first, and then I will.
Whoa. Well, it's a strong lineup. Okay, you're taking 6 minutes.
Yes, Your Honor.
25 minus 6 is 19.
Your Honor, I intend to take 7 minutes, no more.
7 minutes, and you get 12.
Yes, sir.
Oh.
I'll take the balance.
All right.
Your Honor, if I have any left over, I will be glad to give those minutes to them.
Well, we'll see how all that goes. Okay.
All right.
Are we straight? Okay.
All right.
Thank you.
You're more than welcome. Your Honor, I'm Jennifer No, and I am at the Cheatham County Bar, and I'm the city attorney for the town of Ashland City. I want to go back a little bit on this project and how it got started. Mr. Spears, initially part of this property was in the corporation of the town of Ashland City. Mr. Spears approached both the city and Cheatham County with a joint effort to look at annexing this area. So in order to do that, the town of Ashland City is required by statute and an annexation to have a resolution to have a plan of services which provides who will be providing services, police, fire, who will be doing the roads, who will be doing the utilities. Part of that plan of services was that the roads in the subdivision, due to the topography of the land, would be solely private roads and would be the sole responsibility of the developer. There was also provisions made about utilities. Part of this was in Ashland City's utility district, Pleasant utility district, and those were going to have to be worked out as well. In order to have a property annexed, and I think this is very relevant in this case, you're required to have public hearings. Those public hearings, of course, are advertised in a local paper. There is a whole process that you have to go through in order to do annexation. So we had the public hearings, we had plan of services that was approved by the Planning Commission as well as the City Council, and then there was an ordinance that approved not only this property to be annexed, but it was kind of a big conglomerate to clean up some other properties that was also part of this. So the annexation was done and the plan of services was done in December of 2004. Moving forward, Mr. Spears came to the Planning Commission, and of course, the Planning Commission was already aware of the plan of services. They knew that the developer was going to be solely responsible for the roads, that these were going to be private roads, and that the city would never be taking these over as public roads. So the Planning Commission was fully aware of that. And if you look at specifically, the wording is that in Ashland City subdivision regulations, it states that when a bond is required, that the Secretary of the Planning Commission shall endorse approval of the plat after the bond has been approved by the Planning Commission and after all the condition of the resolution pertaining to the plat have been satisfied. This circumstance was different than any other subdivision in that these were private roads. The reason that a municipality gets a bond is to ensure that the roads are done. The provision and the services in this was going to be provided solely by the developer, and then once the roads were done, they would be taken over by the HOA. Therefore, there was not a bond that was required because these were private roads, and therefore, Mr. Spears did comply with our subdivision regs. And normally, plats, when an engineer does a plat, they're basically like forms, and you have all of these little boxes that have to be checked and signed. And normally, if this was a regular subdivision, then you would have your public works director would sign on the little paragraph or the box where it talks about roads. But these, again, were not going to be city roads. Therefore, Mr. Spears signed in that box because he was going to be responsible for the installation of those, and then he would then turn them over to the HOA, and they would be responsible. So when all of this was done,
So no Ashland City official signed to say the roads are completed or there is a bond?
that is correct.
Okay.
Well, if there is no bond requirement, why deny the permit applications for failure to comply with the bond requirement when there is no bond requirement?
So back in 2005, when those plats were done, TCA 13-3-411 simply stated that there was not a requirement that a bond be done or completion of road. The statute changed in between the time that the original plats were done in 2005, 2006, and that time period, and then the law actually changed May the 13th of 2014. And what the legislature did is they added a whole new provision to that TCA that says that it requires a bond or other enforceable guarantee to be done if the street has not been completed before a building permit may be issued. That was not the law back in 2004, 2005. Therefore, the city was not required to get a bond. The law changed May 13th of 2014. Mr. Moore purchased the property, I believe, in November of 2014. So at the time that Mr. Moore had purchased that, the law had changed. And to be honest with the court, it was unbeknownst to the city, and then when we discovered that, we felt like we really didn't have any other opportunity or any other choice but to deny a building permit. And if you look at that change in the law, and even if you look at the history of the law, it doesn't make a distinction between public and private roads. It just says roads. So if you take it on its face, I think again that the city was doing what we thought we were required to do on this change that the legislature had made, and did not issue the building permit. There was testimony at the trial by an expert that the roads had not been completed. And I don't think there's really any issue in regards to that. And kind of addressing the plats, yes, if you are purchasing property, not only are you going to go to the Register of Deeds and look at the plats, but you would also be in contact with the local jurisdiction to find out if there had been a plan of services, if this was a HUD-type program, if there was any other special agreement between the municipality and the developer. And so Mr. Moore would have been put on notice. I don't think this is certainly not a case of unjust enrichment. look at the case that they cited, which was Greenwood, in that case, that is dealing with an ultra-virus contract. That was a case with the city of Lebanon, where Lebanon had contracted with a third party for services, and that there was questions that the council didn't approve that, and therefore it wasn't legally enforceable. And in that case, there had been tons of communications between this third party contractor, and it was a contractual obligation. There was no contractual obligation ever between Mr. Moore and the town of Ashland City. And further, if you look, that Mr. Moore had met with city officials and was told that the city would not be responsible for these roads. And therefore, I do not think we have equitable estoppel at all.
Good morning, Your Honors. Evan Rothy of the Nashville Bar on behalf of BancorpSouth Bank, appellee here and third-party defendant before the trial court below. The trial court granted summary judgment to Bancorp on all of Mr. Moore's third-party claims shortly before this case proceeded to trial. Now, I'm in the curious position that opposing counsel has focused primarily on the other aspects of this case, and so I'll attempt to streamline and simplify my argument this morning. But I will note that the trial court based its decision at summary judgment on multiple independent substantive grounds. And this court may affirm that decision on any of those grounds. But perhaps the simplest basis to affirm the grant of summary judgment to Bancorp is a procedural argument that the trial court did not reach. Mr. Moore's third-party claims are improper in pleader. They are not truly derivative of the HOA's declaratory judgment and injunctive relief claims against Mr. Moore. Put differently, Mr. Moore pursued independent direct claims masquerading as third-party claims. Under the claims, under the facts, and the law pled in this case, Bancorp cannot be liable to Mr. Moore for all or part of his liability on the underlying claims. Even still, this court may also affirm on any of the substantive bases relied on by the trial court. Again, Mr. Moore pursued 3 third-party claims against Bancorp. First, he conditionally sought rescission of the purchase of the property from Bancorp if he was found to lack declarant rights or be responsible for infrastructure improvements. An alternative claim that a judgment should be entered that Bancorp is responsible to contribute towards future infrastructure development in Hidden Lake resorts. And third, that the HOA is responsible to pay, that Bancorp is responsible to pay HOA fees for the period of its ownership of property in Hidden Lake resorts. Now, walking through the bases identified by the trial court, under the merger doctrine, the purchase and sale agreement between Bancorp and Mr. Moore, more specifically the reinstatement, merged into the special warranty deed by which Mr. Moore acquired the property. And the plain language of the deed forecloses Mr. Moore's third-party claims. As an alternative basis, Bancorp negated and Mr. Moore failed to establish the essential elements of his claims at the summary judgment stage, either for failure of consideration to justify rescission, for mutual mistake to justify rescission, or that there was any legal basis that Bancorp owed an obligation towards future infrastructure costs that Mr. Moore might incur. Further, Mr. Moore had no basis to assert that Bancorp was obligated to pay HOA dues for the time of its ownership of the property. Now, I won't touch on all these grounds with my limited time this morning, but I do want to touch on a few overarching aspects of this case. First, this court should affirm summary judgment to Bancorp regardless of its disposition of the other claims in this case. This portion of the appeal deals with Mr. Moore's failure to establish his third-party claims at the summary judgment stage. And going back to the familiar standard from Rye versus Women's Care Center of Memphis, summary judgment should be granted if the non-moving party's evidence at the summary judgment stage is insufficient to establish the existence of a genuine issue of material fact for trial, or the movement affirmatively negates the essential elements of those claims. Tellingly, even on appeal, Mr. Moore's few citations to the record are to trial exhibits and to Mr. Moore's self-serving trial testimony. Before the trial court, Mr. Moore did not supply an additional statement of material facts under Rule of Civil Procedure 56.03. He did not point to the evidence in the record that supported each essential element of his claims, and he has not done so on appeal. And arguably, Your Honors, Mr. Moore did not even address the essential elements of his claims either before the trial court or in his briefing before this court. And Your Honor, I would also note that Mr. Moore's claims fail both procedurally and on the substance. Not only did Mr. Moore fail to establish the essential elements of his claims, but as I mentioned, these are improper in pleader. These claims are not derivative of the underlying claims brought by the HOA against Mr. Moore. And moreover, as a practical matter, Mr. Moore is an admitted, sophisticated businessman. It was undisputed at the summary judgment stage that Mr. Moore and his attorney received the reinstatement document before he signed it. He signed that document. Mr. Moore signed that document, which by its plain language stated that he waived all contingencies and took the property as is. Mr. Moore accepted the risks. The parties allocated the risk to Mr. Moore of this present lawsuit. Now, as a further practical matter, Mr. Moore seeks rescission, but subsequent to his acquisition of the property, he has disposed of large swaths of that property to at least 7 different third parties. So as a practical matter, rescission as a remedy is not possible in this case. I would also want to note one thing that was raised in Mr. Moore's reply brief that was not addressed in prior briefing. He's newly argued that the issues related to Mr. Moore's declarant rights and his infrastructure obligations were collateral to the deed. In that case, this argument undercuts the core elements of his claim. If they are collateral to the deed, then rescission is improper in this case. Further, Mr. Moore has mentioned today the assignment of declarant rights from November 2014 issued or executed between Bancorp and Mr. Moore, saying that it stated that no obligations passed to Mr. Moore. But looking to the plain language of that document, it says that this document represents only that the declarant rights had been assigned. It was not an assignment of obligations. So the plain language of that document that Mr. Moore relies upon merely expresses what the limits of that document were. It's not a declaration that Mr. Moore did not inherit any obligations. It was merely a statement that the declarant rights were assigned through that document.
Let me ask you about the HOA dues from 2011 to 2014.
Yes, sir.
Why would the bank not be responsible for that, since the bank owned the property for that 3-year period? And is there a judgment against Mr. Moore for homeowners' dues during that 3-year period?
Your Honor, starting with that second question, I'm not aware that there is a judgment against Mr. Moore for HOA dues. But going back to your first question, whether the Bancorp is responsible for HOA dues is not before the court, as Mr. Moore did not have standing to address that issue. Mr. Moore is asserting a claim that was arguably held by the HOA, and the HOA did not pursue that. And moreover, Your Honor, even if Mr. Moore did have standing to argue as such, he's waived that. He did not make that argument in his opening brief.
Let me make sure I understand what you're saying. As I understood it, there is a claim against Mr. Moore for HOA dues. Does that claim go back to 2011 through the period from 2011 to 2014?
Your Honor,
if it does, why couldn't he file a third-party action against the bank to recover at least that portion of the HOA dues?
Your Honor, I see I'm out of time. May I answer your question?
Sure.
Your Honor, my understanding is that there is no overlap in the claim for HOA dues between what Mr. Moore's obligation would be and what Bancorp's obligation would be. My understanding is the claim would be limited for the period of Mr. Moore's ownership of the property. Mr. Moore was not being assessed dues for the period of Bancorp's ownership of the property.
All right. That answers me.
Thank you, Your Honor.
Thank you.
Question.
Yes.
You said, I believe, that the document signed by the bank and Mr. Moore was not an assignment of obligations, but that doesn't mean he didn't get them elsewhere. Is that what you said?
Yes, Your Honor. I was merely responding to his argument that the assignment of declarant rights, he argued, foreclosed any assignment of obligations. My argument is that the plain language of that document merely circumscribed that the purpose of the document was to assign declarant rights. It does not address the matter of obligations or infrastructure development. It's separate from that question.
Okay. Okay. Thank you.
Thank you, Your Honor. And we do ask that the court affirm the decision of the trial court.
Please the court, Robert Delaney for Hidden Lake Resorts. I always prepare for these things, and I'll be doggone, the argument ultimately always takes me in a different direction. So I'm going to retool just a little bit. Let me say at the outset, I have the greatest respect for Mr. Manus and Mr. Rassus. They're fine lawyers. Mr. Manus has demonstrated his ability this morning by casting the facts of this matter in a light most favorable to his client, which is exactly what his job is and what he should do. But I would respectfully suggest to everybody that things are a little bit more complicated than Mr. Manus painted them today. I'm sure you all have noticed that we spent some time at the beginning of our brief talking about standards of review, and you all probably thought, well, why in the world are they telling us about that? That's what we do all the time. We know what the standards are. And I pointed that out at the outset of our brief, but not because I didn't think you knew what they were, but because there are several different standards of review at play in this case. As the court knows, there are 8 volumes of transcript here. We spent 8 days trying and arguing this case, 6 in Charlotte and 2 in Ashland City before we got snowed out. And there are over 100 exhibits. And so a lot of testimony was taken, and much of the oral testimony was disputed. For example, there were 3 contracts that Mr. Moore entered into before he ultimately set on one that he was willing to sign to purchase this property. Mr. Manus talks about the fact that he spent $712,000 to buy it. It was a bargain. Mr. Hal Spears, the original developer, had paid $2 million for it, and the bank bid it in for over $2 million. And so initially there was a contract that Mr. Moore presented that was prepared by Mark Hartzog, his original lawyer, to the bank for $850,000. Mr. Moore refused to close on that. And a second contract was entered into, and a new closing date was set. That second contract had a purchase price of $712,000. So in the process, the give and take of all of this with respect to the purchase of the property, Mr. Moore continued to bargain in his favor, consistent with his sophisticated businessman status. And interestingly enough, Mr. Moore has been involved in litigation about very similar issues before this court previously, relating to a development down in Memphis, Tennessee. And this court, there's a reported opinion, which is part of the record in the case, about all that. So Mr. Moore had very specific knowledge about this. The third contract, of course, related to, was the final one that he signed, and it is, quote, an as-is contract. So a lot of the arguments and testimony about the first contract and the special stipulations and so forth, the trial court, we submit, correctly decided that the one that was controlling was the last one, and Mr. Moore bought this property as is. And whatever he says and testified to about that is in conflict with the testimony of Pat Young, who was counsel for BancorpSouth Bank as it related to Hidden Lake Resorts. Respectfully, the trial court made credibility determinations we would submit as to Mr. Moore's version of the facts and Ms. Young's version of the facts and other testimony that was related to that. And we submit that the standard of review the court should apply as to that is abuse of discretion, because the trial court heard the witnesses, judged their demeanor, and decided what he concluded was the most reasonable testimony. Also, we would say that rule applies to negotiations which occurred before and after the signing of the amendments. Again, the record is full of testimony with respect to what Mr. Moore's version and perhaps Mr. Miller's version of those negotiations were. And then the record also contains testimony by Spencer Hamlin, the lawyer for the HOA, Mr. Art Belial, who was a member of the board and an officer in the HOA, and Mr. Richard Chappelle, and respectfully, those versions of the testimony are at odds about those facts, and the court has made credibility determinations we would submit with respect to that. I mean, for example, the court said in its opinion with respect to some of that it found Mr. Moore's testimony unpersuasive with respect to those issues. There are de novo issues as well to be considered by the court. Mr. Manus has talked about the Hughes case. We also think that the trial court relied to some extent on the Willow Grove case. Both of those cases are important. Hughes is not, well, it contains persuasive authority is about how to address this issue. And the Chancellor in the trial court, in fact, I think, approached this case based on the Hughes analysis. He looked initially at the Declaration of Covenants, Conditions, and Restrictions, and the bylaws, which are incorporated into the CC&Rs, if I may short circuit that. He, consistent with Judge Koch's approach, decided that the rules of contractual interpretation should be applied. And there are critical aspects of the CC&Rs that the judge focused on. And one of the things that he focused on, of course, was this concept of general plan of development. And that is provided for in Article 1, Section 10, I believe it is, of the CC&Rs. And basically, Article 1, Section 10 is, in fact, the general plan of development. Another important aspect of the definitional section of the CC&Rs is the definition of supplemental declaration, which is Article 1, Section 15. The plats, the 1 through 5A, are supplemental declarations, I think the court found. And the court, central to the determination of the court in terms of the interpretation of the CC&Rs, I think, is his findings with respect to general plan of development. And in my originally prepared outline, I said this appeal presents a factual circumstance in which the original developer for a planned development in Cheatham County, Tennessee, failed after having established a general plan of development for the planned development that encompassed 881.37 acres of real property. The trial court found that all of that 881.37 acres was subject to the requirements of the CC&Rs. And if you read the definition of general plan of development, it fits just exactly what Mr. Spears did. It hadn't been mentioned in oral argument. I'm sure the court's aware of this, but in order to do this development, Mr. Spears had to get a good portion of Hidden Lakes annexed into the town of Ashland City. Part of it was already in, but a small part. And in order to get that annexation accomplished, he had to promise, he as the declarant and developer for Hidden Lake Resorts had to promise to install the roads, the water, the sewer, the curbs, and the lighting. And the annexation documents, which are exhibited in part of the record, clearly show that all of that is to be done at the developer's expense. Now, you know, Mr. Manus has indicated to the court his view of the record that, you know, Mr. Moore didn't have or had limited information about this, and there was not anything that could have been determined beyond the public record. Well, Mr. Manus, as much as I respect his ability, disagree about that part of it. I mean, the record is replete with information that Mr. Moore accomplished a substantial due diligence. He met with the Pleasant View Utility District. He met with city and county officials down in Cheatham County. He met with a lot of folks. And the court found, and I think the record supports the court, that Mr. Moore and his legal counsel were well aware and had full knowledge of all of the aspects of this development. And certainly they had full knowledge and testified that they read and had an understanding, which was different from ours in some instances, of the CC&Rs and the bylaws. Mr. Moore did not, consistent with his sophisticated businessman approach and knowledge about these kind of developments, went into this with his eyes open as opposed to his eyes closed. And part of the court's findings are that he knew about what his obligations were and tried to avoid doing them. And first he tried to persuade the bank to amend the CC&Rs, to eliminate his obligations to do any of the infrastructure development. Secondly, he tried to get the city and county to let him off the hook and pay for all of this. They refused. And then the next step was to go to the HOA and to try to pressure them into amending the CC&Rs so that they took responsibility for completing the project. And again, it's important that the court found that Mr. Spears presented to the city and county a 10 or 12 phase plan of development. There are exhibits that support all of that. Mr. Spears' undisputed testimony is to that effect. The court found, based on that, there was a general plan of development by which Mr. Spears was attempting to accomplish all of this, and that Mr. Moore stepped into his shoes. I'm sorry, I'm out of time.
I have one more question.
Yes, sir.
Mr. Manus made an extensive argument that based on 5 or so documents, the obligations of the developer were not passed on to Mr. Moore. And there's some very express language in those documents that seem to support that. I won't say they're definitive or anything, but how do you view those documents, that language? That's my question.
Yes, sir. Well, I view that language. First of all, let me say this, and we said this in our brief. There's no case in Tennessee that talks about what the bank's obligation is once it takes its property back in foreclosure. As the court very well knows, other states by statute and by case law have specifically said that banks don't have any obligation to act like a developer. They're just protecting their collateral as long as they don't act like a developer. And in this case, basically, there's none of that. First of all, Pat Young testified that her opinion was that you couldn't separate the obligations that the developer has from the benefits that the developer has. We have cited in our brief case law to the effect that it would be against public policy to do that. And let me just spell it out, Judge Bennett, if I can. I mean, you, the bank, and I, the buyer, can agree to anything that we want to, but there's a third party out there, and that third party are the homeowners who've already been guaranteed certain things by the CC&Rs and the bylaws. If you and I agree to something that's contrary to that, we've deprived that third party of the benefit that they have under that contract, and that cannot be enforceable as a matter of public policy. It can't be enforceable as a matter of contract law, because we have essentially, in our deal, eliminated the rights that those folks have, and based upon which they purchased in the first place, and all of those, of course, are covenants running with the land. So if you interpret the language of, but don't have any of the obligations in the light most favorable to Mr. Moore and Mr. Manus's argument, I would respectfully suggest that this court ought not to uphold that because it violates public policy, and if you will think about it, as a policy matter, if I buy a lot in your development, Judge, and then I build a $300,000 house on it, and then that's all I've got, and then some new developer comes in and says, oh, by the way, you forgot to pay that $50,000 for the completion of these roads. As a practical matter in the state of Tennessee, nobody with any sense is ever going to buy a house in a planned development again. I mean, that's just the plain policy of it. So that's my response to your question.
Thank you.
Yes, sir.
Let me ask you one thing.
Yes, sir, Judge.
In that we're talking about raw land, the as-in provision in the sales agreement between the bank and Mr. Moore, was that just intended to put him on notice that he was accepting the road, sewer, and any other development requirements in the condition they were in at the time of the sale?
Yes, sir. But I think as is, says that. That's the third contract. But in addition to that, I think that clearly the CC&Rs and other governing documents of the development imposed upon Mr. Moore the obligation to carry out the general plan of development that had been established by Mr. Spears. This is a different case than the Hughes case. Your Honor will remember in that case, Judge Cope was presented with sales documents and other non-binding things. The trial court found in this case that the CC&Rs and through the general plan of development imposed obligations on Mr. Moore to complete all that the condition preceding to him being, to the annexation occurring was the fact that whoever the developer was going to complete and pay for all the things that were required by the city as a condition preceding to the annexation occurring. And so while the contract was as is, he took them as he got as they were, but then in addition to that and beyond all that, Your Honor, I would submit that he had the obligation to complete the general plan of development, which had been relied on by the homeowners and the town of Ashland City and everybody else.
Thank you.
Yes, sir.
Rebuttal time. 7 minutes.
Good morning, Your Honors. I'm Mark Rassus of the Clarksville Bar. And let me say, I apologize for the record in this case. It's huge. Some of the exhibits are hard to read, but I can tell you it's important that they be considered, and I know you will. Judge Bennett asked a question that I don't think got answered. The documents clearly express an intent by the bank and the HOA that the subsequent purchaser of the land and lots, that's what he purchased, platted lots and land, did not assume developer obligations. I think the question that Justice Bennett had asked would be, were there any contractual documents that held Mr. Moore responsible? And the answer is absolutely not. In fact, just to the opposite, he disclaimed, as Mr. Manus has said, any obligations. So how else can we hold him responsible if we don't have a contractual liability? And I think that's what Mr. Delaney was trying to get at. He has come up with a theory that's not supported with any Tennessee law or really any law from any other jurisdictions as we've quoted, that if you are a lender or you purchase from a lender, you assume the obligations of the original developer. Now you think about the potential consequences of that. And if you read Judge Wolf's opinion, that's what he says. He says the bank was responsible. The bank could not disclaim the obligations of the original developer that it assumed in a foreclosure sale. So what's that going to do to a potential lender if we set that as a precedent? A potential lender is going to say, well, I want to lend $1 million on this development, but to finish that developer's obligation, it's gonna take $4 million. So if he defaults and I foreclose to get my collateral, I'm assuming $4 million of obligations. That's basically what we have here. And that's not supported by any law. Now, let me just say a couple of little odds and ends. Because time is short, I'm not waiving anything, I'm deferring to my briefs. But as to this as-is argument, the document that Mr. Moore signed does contain as-is language. Mr. Moore has testified that he was given separate pages, that was not on the language that he signed, that previously they had put as-is language which was specifically crossed out. But let's assume that it says as-is, which it does. The same day that happened, the bank on Exhibit 43 provided an assignment of declarant rights. And the bank said in that document, which is Exhibit 43, it says, whereas the grantor is the seller, that's the bank, the assignee is the buyer, and the property pursuant to the terms of the land lot purchase agreement and sale agreement executed by the parties in August 2014. So why would they say, if it's an as-is agreement on the same day, make a condition that says it's related to the other agreement that does not have as-is language? It's enough. Is that enough to rule in Mr. Moore's favor? It's enough to say the summary judgment was premature. There was a disputed issue of fact. But regardless of that, even assuming that it is binding, the as-is agreement is set forth, what is the basis for saying that Mr. Moore is responsible? And that goes with this general plan of development. What is the general plan of development? As Mr. Spears has testified, there is no recorded general plan of development other than the 5 platted lots. The 5 platted lots say clearly at the beginning, and I don't want to waste time sorting through exhibits, but the 5 platted lots say that the common areas and the roadways at the sale of the first lot are dedicated and already transferred to the HOA. So the lots in the land were not property of Mr. Moore. In the special warranty deed he got from the bank, it's excluded the land within the description of the roads. So Mr. Moore did not receive the title to the roads. If he didn't receive the title to the roads, then the general plan of development does not require, if it's the plats which are recorded, it does not require the plats to be an obligation of a subsequent buyer. And that's what it is. We're dealing with 2 things. Was there a contractual basis for that? And the answer is no. Is there any law to support the obligation of an original buyer, of a subsequent buyer from collateral that was based on a foreclosure, and there's not any law? And I'll entertain any questions.
Let me make sure I understand what you argued. Mr. Moore did not buy any of the roads at all, is that?
He clearly in that contract that's referenced, it says the roads are not his, the bank does not own the roads and cannot transfer the roads. In the original CC&Rs, it says when the sale of the first lot occurs, the roads become the property of the HOA. So he never, and in the special warranty deed, it excludes the area within the boundaries of the roads. So he never purchased the roads. He couldn't own the roads. The HOA had to have access to the roads for the 50 or so houses that have already been built and the people have been residing there. So Mr. Moore and the bank excluded it because the bank didn't own the roads. The roads were owned by the CC&R terms and by the dedicated plats. The roads were owned in the property of the HOA. And again, we've got a voluminous record, but that is, even on the 5 dedicated plats, it says they are dedicated, the common area and the roadways are dedicated to the HOA and the members, but not the developer. Thank you.
Thank you. Thanks to all of you. We appreciate your arguments. That is the end of the morning docket, I believe. So if you will